This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Anti-Federalist Papers. Anti-Federalist Paper Number 4. Letters from the Federal Farmer to the Republican, Number 2. October 9th, 1787. Dear Sir, the essential parts of a free and good government are a full and equal representation of the people in the legislature, and the jury trial of the vicinage in the administration of justice. A full and equal representation is that which possesses the same interests, feelings, opinions, and views the people themselves would were they all assembled. A fair representation, therefore, should be so regulated that every order of men in the community, according to the common course of elections, can have a share in it, in order to allow professional men, merchants, traders, farmers, mechanics, etc., to bring a just proportion of their best informed men, respectively, into the legislature. The representation must be considerably numerous. We have about 200 state senators in the United States, and a less number than that of federal representatives cannot clearly be a full representation of this people. In the affairs of internal taxation and police, were there but one legislature for the whole Union, the representation cannot be equal, or the situation of the people proper for one government only, if the extreme parts of the society cannot be represented as fully as the central. It is apparently impracticable that this should be the case in this extensive country. It would be impossible to collect a representation of the parts of the country 500, 600, and 700 miles from the seat of government. Under one general government alone, there could be but one judiciary, one supreme, and a proper number of inferior courts. I think it would be totally impracticable in this case to preserve a due administration of justice, and the real benefits of the jury trial of the vicinage. There are now Supreme Courts in each state in the Union, and a great number of county and other courts subordinate to each Supreme Court. Most of these supreme and inferior courts are itinerant, and hold their sessions in different parts every year of their respective states, counties, and districts. With all these moving courts, our citizens, from the vast extent of the country, must travel very considerable distances from home to find the place where justice is administered. I am not for bringing justice so near to individuals as to afford them any temptation to engage in lawsuits, though I think it one of the greatest benefits in a good government that each citizen should find a court of justice within a reasonable distance, perhaps within a day's travel of his home, so that, without great inconveniences and enormous expense, he may have the advantage of his witnesses and jury. It would be impracticable to derive these advantages from one judiciary. The one Supreme Court at most could only set in the center of the Union, and move once a year into the center of the eastern and southern extremes of it, and in this case each citizen on an average would travel 150 or 200 miles to find this court. That, however, inferior courts might be properly placed in the different counties and districts of the Union, the appellate jurisdiction would be intolerable and expensive. If it were possible to consolidate the states and preserve the features of a free government, still it is evident that the middle states, the parts of the Union about the seat of the government, would enjoy great advantages, while the remote states would experience the many inconveniences of remote provinces. Wealth, offices, and the benefits of government would collect in the center, and the extreme states and their principal towns become much less important. There are other considerations which tend to prove that the idea of one consolidated whole, on free principles, is ill-founded. The laws of a free government rest on the confidence of the people and operate gently, and never can extend their influence very far, if they are executed on free principles about the center, where the benefits of the government induce the people to support it voluntarily. Yet they must be executed on the principles of fear and force in the extremes. This has been the case with every extensive republic of which we have any accurate account. There are certain unalienable and fundamental rights which in forming the social compact ought to be explicitly ascertained and fixed. A free and enlightened people, in forming this compact, will not resign all their rights to those who govern, and they will fix limits to their legislators and rulers, which would soon be plainly seen by those who are governed, as well as by those who govern, and the latter will know they cannot be passed unperceived by the former, and without giving a general alarm. These rights should be made the basis of every constitution, and if a people be so situated, or have such different opinions that they cannot agree in ascertaining and fixing them, it is a very strong argument against their attempting to form one entire society, to live under one system of laws only. I confess I never thought the people of these states differed essentially in these respects. They, having derived all these rights from one common source, the British systems, and having in the formation of their state constitutions discovered that their ideas relative to these rights are very similar. However, it is now said that the states differ so essentially in these respects, and even in the important article of the trial by jury, that when assembled in convention they can agree to no words by which to establish that trial, or by which to ascertain and establish many other of these rights as fundamental articles in the social compact. If so, we proceed to consolidate the states on no solid basis whatever. But I do not pay much regard to the reasons given for not bottoming the new Constitution on a better Bill of Rights. I still believe a complete Federal Bill of Rights to be very practicable. Nevertheless, I acknowledge the proceedings of the Convention furnish my mind with many new and strong reasons against a complete consolidation of the states. They tend to convince me that it cannot be carried with propriety very far, that the Convention have gone much farther in one respect than they found it practicable to go in another, that is, they propose to lodge in this general government very extensive powers nearly, if not altogether, complete and unlimited over the purse and the sword. But in its organization they furnish the strongest proof that the proper limbs or parts of a government to support and execute those powers on proper principles, or in which they can be safely lodged, cannot be formed. These powers must be lodged somewhere in every society, but then they should be lodged where the strength and guardians of the people are collected. They can be wielded or safely used in a free country only by an able executive and judiciary, a respectable senate, and a secure, full, and equal representation of the people. I think the principles I have premised or brought into view are well founded. I think they will not be denied by any fair reasoner. It is in connection with these and other solid principles we are to examine the Constitution. It is not a few democratic phrases or a few well-formed features that will prove its merits, or a few small omissions that will produce its rejection among men of sense. They will inquire, what are the essential powers in a community, and what are nominal ones? Where and how the essential powers shall be lodged to secure government, and to secure true liberty. In examining the proposed Constitution carefully, we must clearly perceive an unnatural separation of these powers from the substantial representation of the people. The state governments will exist with all their governors, senators, representatives, officers, and expenses. In these will be 19/20ths of the representatives of the people. They will have a near connection and their members an immediate intercourse with the people, and the probability is that the state governments will possess the confidence of the people and be considered generally as their immediate guardians. The general government will consist of a new species of executive, a small senate, and a very small House of Representatives. As many citizens will be more than 300 miles from the seat of this government as will be nearer to it. Its judges and officers cannot be very numerous, without making our governments very expensive. Thus will stand the state and the general governments, should the Constitution be adopted without any alterations in their organization. But as to powers, the general government will possess all essential ones, at least on paper, and those of the states a mere shadow of power. And therefore, unless the people shall make some great exertions to restore to the state governments their powers and manners of internal police, as the powers to lay and collect exclusively internal taxes, to govern the militia, and to hold the decisions of their own judicial courts upon their own laws final, the balance cannot possibly continue long, but the state governments must be annihilated or continue to exist for no purpose. It is, however, to be observed that many of the essential powers given the national government are not exclusively given, and the general government may have prudence enough to forbear the exercise of those which may still be exercised by the respective states. But this cannot justify the impropriety of giving powers, the exercise of which prudent men will not attempt, and the imprudent men will, or probably can, exercise only in a manner destructive of free government. The general government, organized as it is, may be adequate to many valuable objects, and be able to carry its laws into execution on proper principles in several cases. but I think its wanest friends will not contend that it can carry all the powers proposed to be lodged in it into effect, without calling to its aid a military force, which must very soon destroy all elective governments in the country, produce anarchy, or establish despotism. Though we cannot have now a complete idea of what will be the operations of the proposed system, we may, allowing things to have their common course, have a very tolerable one. The powers lodged in the general government, if exercised by it, must intimately affect the internal police of the States, as well as external concerns, and there is no reason to expect the numerous State governments and their connections will be very friendly to the execution of federal laws in those internal affairs, which hitherto have been under their own immediate management. There is more reason to believe that the general government, far removed from the people, and none of its members elected oftener than once in 2 years, will be forgot or neglected, and its laws in many cases disregarded, unless a multitude of officers and military force be continually kept in view, and employed to enforce the execution of the laws, and to make the government feared and respected. No position can be truer than this, that in this country either neglected laws or a military execution of them must lead to a revolution and to the destruction of freedom. Neglected laws must first lead to anarchy and confusion, and a military execution of laws is only a shorter way to the same point, despotic government. Yours, and etc., signed, The Federal Farmer. End of Anti-Federalist Papers, Section 4. Letters from the Federal